So the jury decides the facts, but if the plaintiff or the defendant is unhappy with the result, the plaintiff or the defendant can appeal the case to a court of appeal, an appellate court. However, they can only appeal questions of law. And we talked about those a while ago, involving the admission of evidence or the exclusion of evidence. Were the directions that were given to the jury, were those adequate? Were they misleading? Those are the kinds of questions that the appellate court is going to answer. The appellate court cannot go back and revisit the facts. The jury is there to decide what events actually occurred and what's the timeline of those events. The appellate court then is charged with applying rules to the set of facts determined by the jury. The appellate court cannot go back and change the jury's determination of the facts. The facts are what the facts are. An appellate court has to accept the facts as determined by the trial court, the jury, the finder of fact. Now, the appellate court follows its own rules of procedure. There's a separate set of rules of procedure for the appellate courts. Either party can ask the appellate court to review the case. The parties may be in the same configuration as before versus plaintiff and defendant, but they could be switched. If the defendant lost and the defendant brings the appeal, then that party, the party seeking relief, is called the appellant. The party against whom relief is sought is called the appellee. And in fact, both parties can appeal and be appealed against. And what happens in the Court of Appeals level is that each side argues its case to the Court of Appeals. And after having decided the case, the Court of Appeals then issues what's called an opinion. The opinion is going to set out a recitation of what the facts were, what the status of the case was, what is the law that should govern this case, and then applies that law to the facts as determined by the jury. The losing party then can ask the Supreme Court to review the case, but the Supreme Court is not obligated to do so. The Supreme Court can choose whether to hear the case or not. And that's true in state Supreme Courts as well.